Thank you. Work is continuing in relation to the preparation of the Adoption Information and Tracing Bill. The proposed bill will provide for a structured and regulated approach to providing access to adoption information and will facilitate contact for those affected by adoption, including in circumstances where an adoption order was not effected. It is intended that the bill will provide for the Adoption Authority to have access to all adoption records. The bill will provide for a national index of adoption records to be maintained by the Adoption Authority, containing information as to the whereabouts of all known adoption records located within the state. At present, they are in many different settings, and it is envisaged that only the Authority, the HSE, and accredited bodies will hold adoption records, and the Adoption Authority will have overall charge of these records. There's been much concern about the fact that the records are held in many different places, and this bill will ensure that they are gathered together. It's also intended that the bill will provide for placing the National Contact Preference Register, which exists at the moment on a voluntary basis, that will be on a statutory basis. And the purpose of the register is to allow persons affected by adoption to register their names with a view to receiving information about a person from whom they have been separated as a result of adoption, and will allow for registering a preference as to whether or not they want to have contact with that person. A national tracing service will be established, the operation of which will be subject to guidelines which will be set out in regulation. And it is intended that the tracing service will be made available to adoptive persons, birth parents and relatives, with the Adoption Authority having overarching responsibility for the service. It is intended that prior to the release of adoption information, counselling will be offered by the Adoption Authority, the HSE or an accredited body. To an adoptive person, a birth parent, or to an adoptive parent, if, in the opinion of the authority, the HSE or an accredited body, such counselling would be beneficial in the circumstances, or if such counselling is requested by the applicant seeking adoption information.
I have to interrupt the Minister also.
Just to say to you, Deputy, that consideration of the legal and policy issues is ongoing, and once these have been satisfactorily resolved, I intend to seek government approval to publish the heads of the bill. It is my intention to bring the bill before the House's Leo Oireachtas in 2013.
Deputy Joan Collins.
Minister, thanks very much for that reply. I think, like other TDs in the House today, there's a question about how long these are taking to process. I mean, we put a question in May 2012. We were told the work was underway, that was going to be brought in, the heads of the bill was going to be brought in 2012. We're still waiting 9 months on in relation to that bill being brought forward, and it's a very important bill, as you know. I don't know whether you saw the reports, the testimonies of people in the recent papers there, in the 13th to the 1st, of Phil Lynnett's mother, about her experience and other people's experience in trying to track down their parents, and it's just not good enough. I think that since 1975, people in Britain are able to have access to the birth certs, and we still here, 40 years on, are still waiting for that opportunity for those people. And people are very stressed, particularly you're talking about 40 years in Britain, and people are getting older, parents are getting older, people want to contact their parents, they find their parents. Unfortunately, sometimes they've passed on, and I don't think it's good enough. So I really hope that we see this that has been brought in now in this term in relation to the adoption tracing bill.
Thank you, Minister.
I take the point that you're making, Deputy. I mean, this is an area that has been ignored literally for decades. I'm determined to put an end to that. My own view is that it continues to be that an adoptive person over the age of 18 years should have an unrestricted right to obtain a copy of his or her birth certificate, and that an adoptive person under 18 should have a qualified right, perhaps subject to his or her adoptive parent's consent. But I do want to point out that there are pretty serious constitutional issues in this country, unlike in the UK. And, I have had, there is advice from a previous Attorney General, I have to say, that because of the constitutional position of the family in this country, that in terms of open access to birth certs for adoptive persons, that there are constitutional difficulties. Now, what I want to do and what I'm discussing with the Attorney General at present, I'm trying to bring in legislation that gives as much scope to adoptive people to track their records and get access to the information as possible. But I will, of course, be limited by constitutional constraints. And I do have to say that to you, that there is that very strong advice from a previous Attorney General, and indeed indeed our own Attorney General has been examining these issues as well and does advise me about these constitutional limitations. So, you know, we are in a different situation, given our constitution, to the North of Ireland or to the UK. So, I mean, we do have to keep that in mind. But I just want to say to you that my own personal position is to bring in as strong a legislation as I possibly can. But we do have a Supreme Court case as well from the 80s that made it very clear that the mother's right to privacy would have to be balanced against the adoptive person's right to know.
Joan Collins.
Thanks very much for that reply. Obviously, the Constitution has to be addressed, all right. But I mean, the National Adoption Contract Preference Register is obviously there to try and put that framework in place in relation to people not wanting their information given out. But I still think that's very, very important, particularly for medical records, etc., that people have to have access to their parental history in relation to medical history and that. And I think that's going to be really important. And if there's going to be any delay in relation to the general legislation that you want to bring in, that specifically in that aspect, I think legislation should be brought in quite quickly. And I would hope, or do you envisage that because of the constitutional problems, that this could go on longer, or that we could have a less robust legislation coming in this year?
Well, I mean, I do believe the legislation, and I intend that the legislation will come in this year. I don't have any doubt about that. But I'm just alerting you to the constitutional difficulties that are inherent in this legislation. And I will, you know, obviously bring in the strongest possible legislation. But there are clearly the constitutional constraints here. And, you know, access to medical records is, of course, critical. But whether the access to medical records can be provided within given the, you know, the confines of the Constitution in trying to access the information in the first place remains to be seen. It is extremely difficult, given the constitutional position in relation to the family, to have the kind of open access that you were saying that you would like, and which I believe that adoptive parents or adoptive persons ought to have access to. So it is a complex issue. The work is being done on the legislation, and I will bring it to the House. But as I say, there are constraints, and there are constitutional constraints. But I certainly want to have the strongest possible legislation. And just to say to the Deputy as well, that just last week I met with a number of people who had unfortunately been the victims of illegal registrations. And that is another serious issue which we do have to address as well.
Robert Troy.